Hey, welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. Hey, so today it's just me. As I'm recording, it's nighttime on Friday, September 4th. The decision of CCLA in Ontario was just released today, and we thought we'd record it for you guys as a special Labor Day treat. We're going to be hitting you with a bunch of brand new episodes next week and the week after, so definitely stay tuned, but hopefully this will tide you over for the long weekend. Hope you enjoy. CCLA and the Attorney General of Ontario. Heard July 6th, 2020. Decision by Justice Morgan. Part 1. The Impugned Legislation. In May 2019, the Ontario Legislature enacted the Federal Carbon Tax Transparency Act, Section 2.1 of which requires that a notice explaining certain fuel charges be affixed to every gas pump in every gasoline station in Ontario. Under Section 4 of the FCTTA, the notice requirement is enforced by the prospect of substantial fines that can accumulate on a daily basis for as long as the requisite notice is not displayed by the retailer. The form of the notice is a sticker set out in OReg 275-19, the sticker, promulgated pursuant to Section 5 of the FCTTA. There is an English and a French version of the sticker. The regulation requires the sticker to be prominently displayed within the top 2/3 of the side of the gasoline pump that faces motor vehicles when the pump is used to put gasoline into their fuel tanks. The sticker must take the prescribed form, the English version of which is image, saying the federal carbon tax will cost you, featuring the image of a graph headed upwards. At the bottom, 4.4 cents per liter, 2019. At the top of the graph, 11.1 cents per liter, 2022. The information conveyed in the sticker refers to the charges on gasoline imposed by the Federal Greenhouse Gas Pollution Pricing Act, Statutes of Canada, 2018. As can be seen, it is focused on the cost of the federal, quote, carbon tax, a nomenclature used by the province in reference to the charges in issue, but that does not appear in the federal legislation. Under Part 1 of the GGPPA, the amount in issue is referred to as, quote, fuel charge, end quote. The sticker advises that this measure will cost the consumer an additional 4.4 cents per liter of gasoline, which will escalate gradually to a high of 11.1 cents per liter in 3 years' time. The reader is then referred to an Ontario government website for further details about these charges. Those details include information about the Ontario government's own environmental policies and alternatives to the fuel charge, but do not include further information about the federal legislation, how it earmarks and distributes the fuel charge funds, or other initiatives that were enacted by Parliament as part of the overall package of greenhouse emissions policies. The Ontario government characterizes the FCTTA and OReg 275-19 as a notice requirement conveying information relevant to the consuming public. It is Ontario's submission that the policies underlying this legal requirement reflect the legitimate goals of promoting informed consumer choice and price transparency. It is also Ontario's position that the requirement to post this specific form of pricing notice on each gas pump does not limit the ability of gasoline retailers to express themselves, and, moreover, that the sticker itself does not associate gasoline retailers with a message with which they either agree or disagree. The Canadian Civil Liberties Association, CCLA, views the notice requirement imposed by the FCTTA and accompanying regulation to be a form of compelled speech that violates freedom of expression under Section 2B of the Canadian Charter of Rights and Freedoms. It is the CCLA's submission that the mandatory content of the sticker is political messaging rather than genuine consumer information, and it is therefore a rights violation that cannot be justified under Section 1 of the Charter. The CCLA seeks a declaration that subsections 2, 4, and 5 of the FCTTA, along with OReg 275-19, are of no force or effect pursuant to Section 52(1) of the Charter. The parties have agreed that the constitutional challenge is to proceed by way of a motion for summary judgment. Part 2. Origin and purpose of the sticker. As indicated, the sticker turns the reader's attention to the federal GGPPA. That legislation has two substantive parts. Part 1 imposes a fuel charge on a number of different types of fuel and combustible materials, and Part 2 creates a pricing system based on an entity's output of industrial greenhouse gas emissions. The former is administered by the Canada Revenue Agency, while the latter is administered by Environment and Climate Change Canada. The preamble to the GGPPA indicates that provinces and territories may create their own system of emissions pricing if they choose to do so, but that if they do not, or if they create a system that falls short of federal requirements, the fuel charge is applicable and is implemented in that province or territory. The preamble makes it clear that the federal government has enacted this legislation as part of a group of financial incentives for industrial operations to pursue those changes in their operations that will reduce greenhouse gas emissions. For those provinces where the fuel charge is imposed, Sections 165(2) and 188(1) of the GGPPA, along with Section 13 of the Budget Implementation Act, returns some of the proceeds received from the fuel charge to the province of origin as support for the educational, health, business, and Indigenous sectors, and to defray social services and infrastructure costs incurred in the province. The budgetary measures also include the addition of a new Subdivision A.3, Section 122.8 of the Income Tax Act, entitled, quote, Climate Action Incentive. This new section, which provides an income tax reduction or refund to individuals residing in eligible provinces making a claim on their tax returns from 2019 and forward. The federal tax relief is structured as a deemed tax payment linked to the fuel charge payable at the gas pump, with Section 122.86 of the ITA describing the relevant amounts to have been paid in the following terms. Quote, the amount deemed by this section to have been paid on account of tax payable for a taxation year is deemed to have been paid in the year following the taxation year as a rebate in respect of charges levied under Part 1 of the Greenhouse Gas Pollution Pricing Act in respect of the relevant province. As of April 1, 2019, the fuel charge imposed under the GGPPA applies in Ontario. Evidence in the record establishes that the rate charged on gasoline began at about 4.4 cents per litre in April 2019, increasing to 6.6 cents per litre in April 2020. It is further set to rise to 8.8 cents per litre in April of 2021, followed by an increase to 11.1 cents per litre in April of 2022. Likewise, on December 16, 2019, the Minister of Finance designated Ontario as one of the provinces to which the federal rebate and tax incentive program applies. Section 122.84 of the ITA provides the calculation for a basic individual claim of $224 for residents of Ontario, with varying amounts available to be claimed by taxpayers in different family categories and with extra supplements for residents of small and rural communities. It is fair to say that the Government of Ontario has not been in favor of the federal fuel charge. In 2018, it passed an Order in Council 1014/2018, which referred to the Court of Appeal the question of the constitutionality of the GGPPA and its attendant fuel charge. That challenge resulted in a rejection of the Ontario government's point of view. See reference re Greenhouse Pollution Pricing Act. The Court of Appeal held at paragraph 3 that the GGPPA is within federal jurisdiction and that the subject of carbon emissions or greenhouse gases represents a pressing concern across the country and internationally. Quote, "The Act is within Parliament's jurisdiction to legislate in relation to matters of national concern under the Peace, Order, and Good Government Clause of Section 91 of the Constitution Act 1867. Parliament has determined that atmospheric accumulation of greenhouse gases causes climate change that pose an existential threat to human civilization and the global ecosystem." End quote. In addition, the court determined that the fuel charge is not a tax, as that term is understood in Canadian constitutional law. That is, the GGPPA is not, first and foremost, a revenue-raising measure, but rather the fuel charge is enacted as part of a broader regulatory scheme aimed at modifying corporate conduct with respect to carbon emissions. It is therefore a regulatory charge rather than a tax. Moreover, the court reasoned at paragraph 154 that contrary to Ontario's position, the charges levied under a regulatory scheme need not be restricted to cost recovery. Rather, citing 620 Connaught Limited and Canada AG, 2008 SCC, the court confirmed that regulatory fees such as the fuel charge may be designed as a means of altering the behavior targeted in the regulatory scheme. An appeal of the Court of Appeal's decision in the greenhouse reference is scheduled to be argued at the Supreme Court of Canada in the upcoming months. As indicated at the outset, the FCTTA is mandatory legislation. Section 2.1 requires gasoline retailers to obtain copies of the sticker prescribed in OREG 275-19 and to affix it to each gasoline pump in the manner set out in the regulation. Section 4.1 of the FCTTA authorizes penalties for failure to comply with the legislation and regulatory requirements. Schedule 17.1 to the set fine schedules under the Provincial Offences Act provides that on August 30th, 2019, the Chief Justice of the Ontario Court of Justice established fines of $150 per day for an offence under subsection 4.1. The FCTTA was enacted by Parliament and received royal assent on May 29, 2019. The requirement to display stickers on gas pumps, however, came into force on a delayed basis. It only became mandatory for gasoline retailers on August 30, 2019. As CCLA's counsel point out, this was a mere 2 months prior to the October 21, 2019 federal election, in which issues around the environment were central to the election campaign. The affidavit evidence establishes that in the 2019 election campaign, the federal Conservatives and the Liberals had very different views on environmentalism, climate change, greenhouse gas emissions, and what means should be used to address these problems. A Globe and Mail article dated October 15, 2019, a copy of which is an exhibit in the CCLA's motion record, reported that, quote, Leader Andrew Scheer opposes the carbon pricing system, vowing that his party would repeal it and instead use tax incentives, levies on large industrial polluters, and spending on carbon capture technology, end quote. Ontario Premier Doug Ford was quoted in an article in the Canadian Press dated October 28, 2019, to the effect that the carbon tax, as he called it, was a campaign issue which he was following closely in the upcoming federal election. It is the CCLA's position that the key motivation of the governing Progressive Conservatives in Ontario for implementing the sticker policy and the specific motivation for its timing in the run-up to the federal election was to influence the electorate to vote against the incumbent Liberal Party that enacted the FCTTA. The Supreme Court of Canada has indicated that the meaning of a statute can most readily be gleaned from a combination of, quote, the historical background, from statements indicating why the provision was introduced, and from the text of the provision itself, end quote, from Atlantic Lottery Corporation Incorporated and Babstock. The record before me contains a combination of these evidentiary sources, which cumulatively demonstrate that the FCTTA should be understood as forming a part of the Ontario government's engagement with federal partisan politics. On April 18, 2019, with the federal election only months away, and at a time when the bill that became the FCTTA was before the Ontario legislature, Premier Ford identified for the press the central goal of the proposed legislation. Quote, "People in our province have to know how the federal government is gouging them on the worst single tax you could ever put on the backs of people, the backs of businesses." End quote. At the same time, former Ontario Finance Minister Vic Fedeli also identified the partisan battle in which the proposed FCTTA formed an integral part. Quote, "We will be putting stickers on gas pumps that show just how much Justin Trudeau is taking out of your pocket." End quote. From Ontario NDP asks federal elections watchdog to look into Ontario carbon tax sticker campaign. From CBC.ca News, 18th of April 2019, title, Ontario NDP asks federal elections watchdog to look into Ontario carbon tax sticker campaign. The same week, on April 17th, 2019, Ontario's Minister of Energy, Northern Development and Mines, Greg Rickford, stated in the legislature that we're fighting this job-killing, regressive carbon tax. At every opportunity, we're going to let the people of Ontario know where it hurts the most, what they're fueling up in their automobiles. End quote. Legislative Assembly of Ontario, Official Report of Debates, Hansard, Number 95, First Session, 42nd Parliament, 17th of April, 2019. Statements to this effect were likewise made in the legislature by various members of the governing Progressive Conservatives on April 16th, April 18th, May 7th, and May 15th, 2019, all of which were published in Hansard under the heading, quote, Government Advertising. The partisan thrust of the sticker itself and the context of that measure as part of a war of words between the Ontario Conservatives and the federal Liberals was reiterated on several occasions in the legislature by Minister Rickford. See, for example, the Legislative Assembly of Ontario Official Report of Debates, Hansard, Number 96, First Session, 42nd Parliament, 18th of April, 2019. Quote, "We're hearing the radio stations talk about the carbon tax. It seems like the federal government, there's no amount of money that they will spend to talk about and tout this job-killing regressive carbon tax. We feel differently. We think that a sticker at the gas pump with some public notice is an important way of letting people of Ontario know how much this tax scheme is going to cost them. Imagine them putting their hand in one pocket and saying, it's not going to cost you. It's not available to the federal government to spend unlimited resources on touting a tax that's going to kill jobs." End quote. It is the CCLA's position that these statements by the Premier and Ontario Cabinet members encompass the thrust of the FCTTA and OREG 275-19. Following the Supreme Court's guidance, quote, "The statements recounted here were made by those directly responsible for introducing the policy and issue, and such provide relevant evidence of legislative purpose." End quote. From Babstock at paragraph 46. Counsel for the CCLA submits that it is the adversarial political context, evidenced in Hansard and the media, that gives those enactments their true meaning. Part 3. The CCLA's involvement. It is Ontario's position that the CCLA lacks standing to bring the present action. Counsel for the province contended that the CCLA lacks a, quote, genuine interest, end quote, in the case, and that it is not directly impacted by the outcome of the proceedings. The CCLA, on the other hand, contends that it has sufficient interest in the proceeding to give it standing as a challenger, and that while it lacks a direct personal or financial interest, it is fully engaged with the issues raised in this case. The FCTTA was first announced in Ontario's April 2019 budget. Shortly thereafter, on April 29, 2019, the CCLA, through its counsel, sent a letter to the provincial government notifying it that the proposed policy amounted to compelled speech and would be a violation of Section 2B of the Charter. A little over a week later, the CCLA's executive director appeared before a legislative committee considering the bill and made the same point, stating that, quote, "The government is perfectly free, obviously, to undertake its fight against the federal government and fight against the carbon tax. But to play ventriloquist and to ask businesses and citizens to be the dummy, to ape the political message of the government, is compelled speech," end quote. This position was reiterated on June 7, 2019, upon the government's invitation to the public to comment on the proposed legislation and regulation. The CCLA submitted that either no legislation be enacted or a more politically neutral conveying of information about the fuel charge be adopted. In acting with immediacy and in taking position in support of freedom of expression, the CCLA conformed with its history as a prominent civil liberties organization in the province. Its role in developing the law of civil liberties and human rights in Ontario has been noted by the courts on numerous occasions. Incorporation of the Canadian Civil Liberties Association and Ontario Ministry of Education, Justice Watt observed that, quote, "The CCLA, a national organization created in 1964, actively promotes respect for and the observance of fundamental human rights and civil liberties," end quote. Likewise, in Tadros and Peel Regional Police Services, Justice O'Connor expressly recognized that the CCLA, quote, "has substantial experience in promoting and defending the civil liberties of Canadians," end quote. It has done so in legislative committees, as a friend of the court in cases raising significant civil liberties issues, and as a party challenger in its own right in constitutional and human rights cases. The courts have held that defense of civil liberties and constitutional rights is the CCLA's mission, and in involving itself from the outset in the policy debate and legislative facts giving rise to the present case, it was fulfilling a fundamental aspect of its goals as an organization. The CCLA has submitted affidavit evidence setting out that it made efforts to find a gas retailer to act as a plaintiff or co-plaintiff herein. Those efforts were unsuccessful, perhaps due to the politically prominent nature of the issues at stake. As the CCLA's affiant explains it, various gasoline retailers, when contacted by representatives of the CCLA, reacted with concern about suing the government that regulates them. They also expressed a wariness of publicly embracing a political position with which some of their customers may take issue. Ironically, it is the CCLA's very point about the impugned legislation and regulation, i.e., that it is intrinsically wed to partisan politics, that has prevented it from convincing any retailer to join it or take this challenge in its own right as named plaintiff. Furthermore, the CCLA's position is that there is a more than adequate record of legislative facts on which the court can proceed, and that the nature of the case is such that facts relating to any one gasoline retailer are not necessary to the constitutional challenge. Indeed, CCLA's counsel argue that the legislative facts themselves set out the message that the Ontario government requires gasoline retailers to deliver, and so incorporates the necessary adjudicative facts for this challenge. They therefore submit that the facts in the record, including the requirements contained in the legislation and the design of the sticker contained in the regulation thereunder, suffice in, quote, helping to establish the purpose and background of legislation, including the social, economic, and cultural context in which the legislation was enacted, end quote, from the Queen and Levkovic. As a further part of the factual record, the CCLA also relies on the legislative debates and the Ontario government media statements surrounding the enactment of the FCTTA and the implementation of the sticker. The media statements by provincial government members are not uncontroversial in the sense that they appeared in the mainstream press and their existence is not challenged. The statements in the legislature are likewise admissible to assist the court in determining the purpose of a legislative enactment, and can reliably serve as evidence of legislative purpose where the statements in the legislature are those of government ministers introducing or explaining a bill. Part 4. Public Interest Standing. In the absence of a challenger with a direct personal interest in the outcome of this litigation, the CCLA seeks public interest standing to bring the claim. In evaluating such a request, the Supreme Court of Canada in Canada AG in Downtown Eastside Sex Workers United Against Violence Society has instructed courts to look to 3 factors. A. Is a serious justiciable issue being raised? B. Does the applicant have a real stake or genuine interest in the issue? C. Under the circumstances, is this a reasonable and effective way to bring the issue to court? As CCLA's counsel point out, the discretion as to whether to grant public interest standing is to be exercised in a, quote, liberal and generous manner, end quote. Counsel for Ontario puts up little argument that the issue at hand is not a serious and justiciable one. The alleged Speech Act at the center of the constitutional challenge is not frivolous or novel, and although it occurs in a retail setting, is not the mere sale of a product. The FCTTA expressly requires the conveying of information by gasoline retailers to their customers, which, as discussed in Part 5 below, is certainly within the broad definition of expressive activity embraced by the Supreme Court of Canada. See Irwin Toy Limited and Quebec AG. Moreover, among public interest groups, the CCLA is not alone in voicing concern about the requirements of the FCTTA and OReg 275-19. Affidavit and other evidence in the record before me establishes that Greenpeace Canada has made it clear to the Government of Ontario that it views the sticker requirements as a violation of freedom of expression under the Charter. Likewise, the Ontario Chamber of Commerce has informed the government that gas station operators are concerned about what they view as the political character of the required sticker, and that they perceive the mandatory policy as a violation of their charter rights. In a similar fashion, the Canadian Independent Petroleum Marketers Association has observed publicly that the partisan content of the stickers, combined with the penalties contained in the FCTTA, amount to a rights violation that is particularly detrimental to the operation of small businesses. Finally, the intervener in this case, PEN Canada, a venerable defender of free expression, has joined the CCLA in challenging the constitutionality of the provincial legislation and regulation that make mandatory the public display of the sticker. The supporting viewpoints of these groups is not determinative of the legal issues in the case. Nevertheless, the fact that public interest organizations representing a number of different sectors in society have expressed objection to the legislation and regulation on similar legal grounds to those of the CCLA is significant in establishing that the challenge raises a, quote, substantial consequential issue and an important one that is far from frivolous, end quote. The record also establishes without qualification that the CCLA's interest in the issue raised by the case is genuine, and that it has a track record of engagement with the constitutional issue at hand. The CCLA has been acknowledged by the courts to be an, quote, experienced and qualified public litigant, end quote. See Landau and Ontario AG. It has a lengthy record of involving itself in public interest litigation, including a number of freedom of expression cases argued at the Supreme Court of Canada. See the Queen and Keegstra, Little Sisters Book and Art Emporium in Canada, the Queen and National Post, and the Queen and Butler. Public interest litigants can gain standing when they have demonstrated a genuine interest in the issues by publishing on the topic, participating in committee hearings relating to the legislation, and establishing a history of expertise in the area. See Alford in Canada AG. The CCLA has engaged in all of those activities, and more, in relation to the issue before the court. Its interest in the case reflects the core of the civil liberties and constitutional law mandate which it exists to defend, and as an organization it has the capacity to take on this litigation. In addition to all of that, allowing the CCLA public interest standing is a reasonable way to bring the issues to court. While any gas retailer in the province could potentially be a plaintiff in this action, the existence of other potential plaintiffs must be considered realistically in considering the CCLA's request for standing. The CCLA has provided evidence of efforts it has made to find a gas retailer to act as co-plaintiff. As I already indicated, the record shows that retailers, with a view to market forces rather than to politics and constitutional law, have been loath to participate in this case. Unlike gasoline retailers, the CCLA is not subject to the changing winds of public opinion and the retail market. I conclude that this is an appropriate case in which to grant public interest litigant status to the CCLA. Part 5. Freedom of expression and compelled speech. The expression protected by Section 2B of the Charter, quote, can be conveyed through an infinite variety of forms of expression. For example, the written or spoken word, the arts, and even physical gestures or acts, end quote, from Irwin Toy Limited and Quebec AG. Certain conduct, such as labor strikes or acts of criminal violence, have been specifically excluded from the scope of constitutional protection. See Reference Republic Service Employee Relations Act and RWDSU and Dolphin Delivery. Otherwise, quote, Section 2B of the Charter embraces all content of expression, irrespective of the particular meaning or message sought to be conveyed, end quote, from the Queen and Keegstra. The Supreme Court of Canada has said since its earliest jurisprudence under Section 2B that, quote, if the activity conveys or attempts to convey meaning, it has expressive content and prima facie falls within the scope of the guarantee, end quote, from Irwin Toy. Importantly, this freedom, quote, encompasses the right not to express views, end quote, from Rosen and Ontario AG. As the Supreme Court explained in Slate Communications Incorporated and Davidson, quote, there is no denying that freedom of expression necessarily entails the right to say nothing or the right not to say certain things. Silence is in itself a form of expression, which in some circumstances can express something more clearly than words could do, end quote. In previous cases, the right not to express a government's preferred point of view has been applied to persons who oppose socially positive messages, such as health warnings. See RJR MacDonald Incorporated and Canada AG. Likewise, the Section 2B right has been found to include the right to refrain from expressing objective, uncontested facts. See Slate Communication. The Court made it clear in Committee for the Commonwealth of Canada and Canada that the Charter not only protects people from having to express a message with which they disagree or with which they do not want to associate themselves, but it also guarantees the corresponding right not to have to listen to such a message. The freedom sought by the CCLA here can be characterized as an expansive one. The sticker itself may be relatively small. It fits neatly onto the face of a gas tank. But that does not mean that the burden on the gasoline retailer compelled to post it can be dismissed as trivial or insubstantial. In fact, the principle at stake is substantial when seen from the point of view of the retailer, its customers, and of a rights-based society in general. As the Supreme Court observed in Levine and Opsu, a statutory requirement whose effect is, quote, to put a particular message into the mouth of the plaintiff, end quote, will run afoul of Section 2B of the Charter. In McTeer and AG Canada, the Court of Appeal set out 3 questions to be addressed in analyzing a Section 2B challenge alleging government-compelled expression. Quote, the first question is whether the activity in which the CCLA is being forced to engage is expression. The second question is whether the purpose of the law is aimed at controlling expression. If it is, a finding of a violation of Section 2B is automatic. If the purpose of the law is not to control expression, then in order to establish an infringement of a person's charter right, the claimant must show that the law has an adverse effect on expression. In addition, the claimant must demonstrate that the meaning he or she wishes to convey relates to the purposes underlying the guarantee of free expression, such that the law warrants constitutional disapprobation, end quote. The first McTeer question is not a difficult one under the circumstances. As discussed above, the definition of expressive activity for the purpose of the Section 2B guarantee is extremely broad. There can be little doubt that a sticker designed to convey a specific message to the consumer of gasoline, whatever that message might be, falls within its definition. Indeed, the placing of a sticker in a publicly visible locale is so analogous as to be identical to the placing of, quote, public signs and posters which are a form of expression protected by 2B of the Charter, end quote. See Ramsden and Peterborough City. Since the sticker is a form of expression, and Section 2, 1, and 4 of the FCTTA use mandatory language and require, under threat of penalty, the display of the sticker, it follows that the challenge law compels expression. The second McTeer question is less straightforward. The problem is that counsel for the CCLA has misstated it in making its submissions. The question is not, as paraphrased in CCLA's factum, whether the purpose of the law is aimed at compelling expression, but rather whether the purpose of the law is aimed at controlling expression. Since the first question is answered in the affirmative, that is, the law does in fact compel expression, then of course its purpose is to do so. The impugned provisions of the FCTTA and OReg 275-19 have no other purpose than to do what they do: to compel the placement of the prescribed sticker on gasoline tanks in order to convey a message to customers. The question posed by the McTeer analysis, however, is a different one. Is the law designed not so much to compel a specific message, but to control any message the gasoline retailer might otherwise express? The CCLA contends that gasoline retailers would like to remain silent on the question of fuel charges under the federal GGPPA addressed by the compulsory sticker. That seems likely in view of the fact that despite investing some effort, the CCLA was unable to come up with a gasoline retailer willing to join this litigation as a co-plaintiff. But while that realistic likelihood may suffice to give the CCLA standing to launch the constitutional challenge on its own as the most convenient way to bring the matter to court, it does so as a pragmatic procedural consideration. It does not, however, amount to a body of evidence of the retailer's intended viewpoint or expression. In any case, it would be difficult for government to control expression by compelling certain messages in the FCTTA, but not restricting others. By way of illustration, the CCLA complains that the sticker conveys accurate but incomplete information about the fuel charge, and that these half-truths are misleading. CCLA's counsel in their factum submit that the sticker, quote, does not tell consumers that there are other costs and other taxes which are blended into the price of gas, end quote. They further submit that the sticker, quote, deliberately omits significant information about the federal rebate, which forms part of the greenhouse gas package of initiatives, which could negate the economic impact of the fuel charge on consumers, end quote. It is self-evident that any gasoline retailers that were so inclined could fill the missing information in for themselves. Nonetheless, nothing in the FCTTA prevents them from designing a sticker or even a giant billboard of their own, in addition to the mandatory sticker. The Court of Appeal made a similar point in McAteer, at paragraph 77, commenting that it is necessary to consider not only the compelled nature of the required expression, but to consider, quote, whether the legislation in issue has the effect of chilling or impairing freedom of expression in determining whether there had been a violation of Section 2B, end quote. The court explained its reasoning by reference to the Supreme Court of Canada jurisprudence, which lays the foundation for the analysis, at paragraph 76. Quote, the opportunity to publicly disavow a message is relevant to the determination of whether there is a Section 2B violation. In Levine, Justice Wilson, with whom Justices Leray-Dubé and Corey agreed, stated that this court has already accepted that public identification and opportunity to disavow are relevant to the determination of whether Section 2B has been violated. The Supreme Court came to a similar conclusion in Slate Communications, Inc. and Davidson. These factors are important because, as Justice Wilson noted in Levine, if a law does not really deprive one of the ability to speak one's mind, or does not effectively associate one with a message with which one disagrees, it is difficult to see how one's right to pursue truth, participate in the community, or fulfill oneself is denied, end quote. Since the impugned legislation and regulation compel the sticker message but nowhere deprive one of the ability to disavow or disassociate oneself with it, the law is designed to compel expression but not control it in the constitutionally understood sense. There is, accordingly, no automatic violation of Section 2B as there would be for government action which both compels and controls expression. The crux of the problem with the impugned legislation and regulation lies in the answer to the third McTeer question. Does the law adversely affect expression? And is this effect related to the purposes of the freedom of expression guarantee? The Court of Appeal found that, like here, the impugned government measure had an incidental effect on expression. That is, the measure caused persons to speak when they might want to be silent, whether or not they agree or disagree with the legislatively compelled message. In McTeer, the compulsion to convey the prescribed message, the oath of citizenship, was on threat of losing access to a benefit, Canadian citizenship. In the present case, the compulsion is on threat of incurring a burden, a fine. But in this context, a benefit and a burden are just different sides of the same coin. The Court of Appeal went on to reason that for 5 distinct reasons, this adverse effect did not relate to the underlying purposes of Section 2B. While some of those reasons apply equally to the case at bar, not all of them do. In fact, there is one crucial difference between the compelled speech in McTeer and the compelled speech under the FCTTA, and that is that the speech at issue in McTeer was of a nature that fostered the rule of law, whereas the speech at issue here arguably countermands the rule of law. The first point identified by the Court of Appeal in McTeer at paragraph 76 is that the affected individuals have the opportunity, quote, to publicly disavow what they consider to be the message conveyed by the oath, end quote, i.e. the message compelled by the relevant legislation. As discussed above, that is equally the case here. Any gasoline retailer is at liberty to add the information that the CCLA has identified as lacking to fully explain the details and impact of the federal government's GGPPA fuel charge. While every such retailer must post the sticker, that is the end of their obligation in that respect. Nothing in the FCTTA or OREG 275-19 prohibits them from posting a separate sticker expressing the fallacy of the information contained on the prescribed sticker if they so desire. The second point identified by the Court of Appeal in McTeer at paragraph 81 is that the challenger's understanding of the compelled message represented a misapprehension of the meaning of the message. That may or may not be a relevant factor in the case at bar. While there is no evidence as to what any given retailer thinks the sticker means, there is ample evidence from reliable sources as to what the government thinks the sticker means. The problem is that evidence from government sources points in several different directions. The question of whether the public is operating under a misapprehension of the import of the sticker message ultimately depends on whether government members are being forthright in articulating their own understanding of the compelled message. That understanding will be discussed below. The Court of Appeal's third point in McTeer at paragraph 82 is that even if the offending words of the compelled message were revised or eliminated, such a remedy would, quote, only be a superficial cure for the appellant's complaint, end quote. That is, the challengers, like here, may want to say absolutely nothing. Being made to say something innocuous does not exactly accomplish that goal. Indeed, it might not be possible to say something entirely innocuous and still articulate anything resembling the government's preferred message. The Court of Appeal's fourth and fifth points in McTeer at paragraphs 83 and 84 essentially amount to one overarching and important point. In prescribing the compelled speech at issue in that case, the government was fulfilling a number of its properly mandated functions, including the protection and promotion of Canada's national and legal culture. More specifically, the court at paragraph 74 specifically observed that the compelled expression in that case, quote, promotes the unwritten constitutional principles of the rule of law and democracy, end quote. The same cannot be said of the sticker. As already explained, it is Ontario's position that the content of the sticker is merely information conveying and is designed for the purpose of informing the consumer about the cost of gasoline and the fuel charge imposed by the GGPPA. However, the information thereby conveyed is incomplete in such a significant way that it does not convey the true state of facts. In fact, Even the label, quote, federal carbon tax that appears in bold, red font at the top of the sticker is a misnomer and an adversarial slogan, albeit a recognizable one and understandable from a public advocacy point of view. Not only is the use of this nomenclature inaccurate from a strictly legal point of view, it is inaccurate in a way that the Ontario government well knows. As discussed in Part 2 above, the Court of Appeal and Reference Re Greenhouse Pollution Pricing Act already determined that the fuel charge is a valid federal regulatory enactment under the Peace, Order, and Good Government Clause of Section 91 of the Constitution Act, rather than under the federal taxing power in Section 91(3). In other words, it was enacted for regulatory purposes rather than for revenue-raising purposes, and so is a regulatory charge and not a tax. Persisting in calling it a carbon tax would be perfectly acceptable in political advertising or in a politician's speech, but it is an intentional use of spin that reveals the advocacy rather than informational thrust of the message. Moreover, as also discussed above, the federal government, for better or worse, has enacted a two-part policy, one being a fuel charge and the other being a rebate to designated provinces and tax relief to individuals in those provinces. The sticker purports to explain the true cost of the federal fuel charge, but omits the federal rebate and climate action incentive provisions of the ITA. That kind of half-truth is not very truthful. While a rebate and tax refund program may not lower the price of gas at the pump, they are self-evidently a relevant part of the pricing package. Again, there is nothing altogether unusual about government members explaining a policy measure in partial or incomplete way during the course of a political campaign. For example, a politician who campaigns on a promise to lower the cost of housing or of an essential service may not feel a need to explain every detail of how the price adjustment will impact on other aspects of the economy. This approach, however, is emblematic of the public relations and advocacy aspects of politics and should not be confused with genuine, viewpoint-neutral information sharing. What is important here is therefore not that the prescribed sticker is inaccurate or guilty of significant omissions, but rather that in designating the sticker and making it mandatory, the government is trying to accomplish a task that is only coincidentally related to conveying the price of automobile fuel of carbon emissions. That is, the government is not so much explaining a policy, but is rather making a partisan argument. In placing its version of fuel charge information on every gas pump in the province, the government is attempting to, in Premier Ford's words, demonstrate to Ontarians how the governing federal Liberals are, quote, gouging them, end quote. In this way, the FCTTA and OREG 27519 create not so much consumer messages, but political missives. The sticker's information about the fuel charge is really a reversal of a well-known Canadian aphorism. It is the medium, but it is not, in fact, the message. The message is that the incumbent party in Ontario has better policy ideas than the incumbent party in Ottawa. That is perfectly acceptable messaging in a political campaign, but is not the one that the government has purported to enact. It takes little effort to distinguish a partisan message aimed at opposing political party from a prescribed measure that, quote, promotes the unwritten constitutional principles of the rule of law and democracy, end quote, to use the McAteer description of a constitutionally appropriate form of compelled speech. It is essential to the concept of the rule of law that the law does not serve political leaders, but rather political leaders serve the law, from Ronsorelli and Duplessis. By using the law for partisan ends, the Ontario legislature has enacted a measure that runs counter to, rather than in furtherance of, the purposes underlying freedom of expression. As the Court of Appeal put it in McAteer, at paragraph 69, this type of compelled expression, quote, warrants constitutional disapprobation, end quote. Part 6 is the infringement justifiable. It is accurate to say that the best way of discerning legislative purpose, quote, will usually be to look to the legislation itself, end quote, Frank and Canada AG. But that does not mean that the legislative language must be taken at face value. In this respect, the FCTTA and OReg 275-19 must be viewed in light of what they expressly convey, what they omit, the context in which they were enacted, and the statements in the legislature of the government members that introduced the measures. Sticking strictly to the legislative language is only reliable where the context supports the language used. Without putting too fine a point on it, scholars of statutory interpretation have observed that statutes are enacted by legislators and politicians, and that, quote, politicians sometimes misrepresent their actual policy preferences, end quote. Counsel for Ontario submit in their factum that, quote, the impugned provisions of the FCTTA and OReg 275-19 are straightforward, end quote. In one sense, this is accurate. The legislation and sticker design are easy to understand from the perspective of the retailers required to adhere to the policy. In another sense, however, the statutory regulatory enactment is deceptive in that it cloaks subjective advocacy about a federal legislative initiative in the language of objective information sharing. For example, in labeling itself the Federal Carbon Tax Transparency Act, emphasis added on transparency, but in making transparent only those aspects of the federal policy that fit the Government of Ontario's political narrative, the statute speaks in the voice of an unreliable narrator. It is a telltale heart approach to drafting, as where the ostensibly objective narrator of Edgar Allan Poe's famous tale is revealed as ultimately complicit in the acts he describes and their mode of description. To invoke a colloquialism, the statute exudes anger, i.e. opposition, but says that it is justice appointed, i.e. transparent. Accordingly, the impugned legislation and regulation fail the first stage of the test under Section 1 of the Charter, see the Queen and Oaks. While truly informing the public about the components that make up the cost of gasoline would be a pressing and substantial government objective, promoting the Ontario governing party over the federal governing party is not. As scholars of public policy have pointed out, quote, the core distinction between partisan advantage-seeking and political decision-making is that partisan advantage-seeking is concerned primarily or solely with providing a benefit or rent to the governing party, while political decisions are matters of public policy choice, end quote. From Cale Hatt's The Abuse of Government Advertising, examining partisan advantage-seeking and parliamentary innovation designed to eliminate misuse. Public policy choices can reflect pressing and substantial objectives in the Oaks test sense of that phrase, while partisan advantage-seeking by definition does not. Even if one were to conclude that the legislative objective is a hybrid of policy and partisanship, and that the Government of Ontario intended to, quote, kill two birds with one stone, quote, as it were, by making gasoline pricing information available to the public, but also designing the sticker in a way which implicitly criticized the federal government, the infringement of Section 2B would be disproportionate to any beneficial objective it served. That is, the hybrid objective might pass the pressing and substantial hurdle of the Oaks test, but it would falter on the final proportionality hurdle. The salutary benefit of information conveyed by requiring a sticker on every gas tank would be far outweighed by the deleterious effect of using legislative and regulatory power for partisan ends. As a means of testing this contest between the two values, it is worth making reference to the argument posed by counsel for Ontario with respect to the voice in which the sticker speaks. It is Ontario's position that there are numerous justifiable instances of compelled expression in law. Thus, for example, the Ontario Health and Safety Act requires a copy of the statute to be posted in every place of employment in the province. The Smoke-Free Ontario Act requires no smoking signs to be posted throughout any enclosed workplace. The Ontario Building Code requires exit signs to be placed over every exit door, and etc. The difference, according to Ontario's counsel, between a justified and an unjustified use of legislative power to compel private persons or companies to post signs, posters, or stickers turns on whether the prescribed signage purports to speak in the private party's voice. In other words, counsel argues that the government can tell people to post signs about things the public needs to know, as long as it speaks in its own voice. It cannot, however, make a private employer or building owner speak through mandatory signage in which appears to be the private party's voice. Thus, the City of Toronto bylaw can require a sign on a restaurant door announcing the date and result of a Toronto public health inspection, but it could not, hypothetically, require signage announcing that the health inspector was here today and that she did a great job. The former conveys public policy information in the government's neutral voice, while the latter expresses a subjective viewpoint and imposes it in the private owner's voice. I accept that there are justified instances of compelled expression, as illustrated above. I also accept that compelled messages that speak in the government's voice are in many instances more likely to fall within the justifiable category than compelled messages that mimic the private party's voice. I do not agree, however, that the voice of the required message is the end of the analysis. One can imagine instances where a mandatory sign is explicitly in the voice of the government, but the message nevertheless reflects a value whose effect is more deleterious than beneficial. In that case, it will not be justified regardless of the voice in which the message sounds. One obvious example will suffice to demonstrate the point. The ultimate partisan thrust of the FCTTA and the sticker was put most clearly in the legislature by Energy Minister Rickford on April 16, 2019. On that date, the minister announced, quote, "We're going to stick it to the Liberals and remind the people of Ontario how much this job-killing, regressive carbon tax costs," end quote. Legislative Assembly of Ontario, Official Report of Debates, Hansard, Number 94, First Session, 42nd Parliament, 16th of April 2019. It is the CCLA's view that, in fact, the dramatic language and half-truths of the sticker are meant to do precisely what the Minister of Energy conceded, i.e., to goad the government's political adversaries. Could the Ontario government, speaking in its own voice, require a gas pump sticker that says explicitly what the Minister of Energy says it means implicitly? To ask this rhetorical question is to answer it. A mandatory sticker that said, "Stick it to the Liberals," might not speak in the gasoline retailer's voice. It could even be prefaced with the phrase, "Ontario says," but the message would be blatantly advantage-seeking by a political party and a misuse of the governing party's legislative power. Its deleterious effect on democratic governance would certainly outweigh any salutary benefit of information it contained. The final step in the Oakes analysis, quote, requires placing colliding values and interests side by side and balancing them according to their weight, end quote, the Queening KRJ. The Supreme Court has made it clear that use of legislative executive power for partisan purposes amounts to, quote, an unjustified attempt to legislate or regulate to benefit the governing party, end quote, from reference re Saskatchewan electoral boundaries. With this admonition in mind, it is obvious that the sticker could not be designed to say what the Government of Ontario says it really means. It would be an insurmountable hurdle for Ontario to require a sticker that uses explicitly partisan rather than ostensibly neutral language, and then to establish that the benefit of its bona fide public policy choice outweighed the detriment of its self-interested, partisan use of government power. Accordingly, the FCTTA and OReg 275-19 cannot be justified under Section 1 of the Charter. Part 7. Disposition. A government or political party can, in the words of Ontario's Minister of Energy, quote, stick it to, end quote, another tier of government or political party as a matter of free speech in an election campaign or otherwise. But a government cannot legislate a requirement that private retailers post a sticker designed to accomplish that task. The mandatory fuel pump sticker is an unconstitutional attempt to do just that. Sections 2, 4, and 5 of the FCTTA and OReg 275-19 violate Section 2B of the Charter and are of no force or effect. Gasoline retailers are at liberty to keep the stickers on their fuel pumps or remove them as they see fit. Released September 4th, 2020.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.